And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
Imagine if the most popular rifle in America, the AR-15 and the standard capacity magazines that go with it, were suddenly declared to be completely outside the protections of the Second Amendment. This isn't just some scary hypothetical or a debate for law school classrooms. That exact question is currently sitting on the desk of the Supreme Court for a final history-making decision. The question before the justices is simple, direct, and potentially devastating. Does the Second Amendment actually guarantee your right to possess AR-15s and standard magazines, or can the government simply ban them out of existence? Today, on Law Advisor, we need to talk about the massive news breaking in this case and what is really happening behind the scenes in these critical challenges. But before we dive into this legal chaos, if you want to support our mission of bringing you the truth that the mainstream media refuses to cover, the best way to do that is simply to hit the subscribe button. We are in a race to reach our first 1,000 subscribers, and every single one of you counts. Also, double check to make sure YouTube hasn't unsubscribed you, because we've seen that happen quite a bit lately with channels that defend your freedom. I also want to thank our supporters at Attorneys on Retainer. When it comes to self-defense protection, they are truly in a league of their own. They are a real law firm, and they now guarantee 4 attorneys for your specific case if you ever have to use your firearm to protect your life. You can use the code ARMSCHOLAR at the link below to get a discount on your membership. Now, let's get into the details that matter. We are talking about a critical challenge against rifle and magazine bans that is currently in front of the Supreme Court and is heading back to the Justices' private conference this very week. The primary case you need to keep your eyes on is Viramontes versus Cook County. In this lawsuit, individual citizens and civil rights organizations are suing Cook County, Illinois, challenging an ordinance that makes it a crime to sell, transfer, or even possess so-called assault weapons. The problem is that the county's definition is so broad that it bans over 100 different models of rifles by name, including every AR-15 and AK-47 platform. On top of that, they've created a feature ban. If your semi-automatic rifle has a pistol grip, a folding stock, or a muzzle brake, it is automatically classified as an illegal assault weapon. The petitioners argue that this isn't regulation. It is an outright ban on some of the most common and popular firearms in the country, which are explicitly protected by the Second Amendment. They say this law flies directly in the face of Supreme Court precedents like Heller and Bruin. What makes this case the perfect vehicle for a landmark decision is that it attempts to collect on a promise made by Justice Kavanaugh. Last year, when the court declined to hear a similar case from Illinois, Kavanaugh issued a statement saying that the time would come very soon for the Supreme Court to address the issue of semi-automatic rifles, possibly in a term or two. Well, that time has officially arrived. The Supreme Court has once again relisted this rifle case for review, along with the Duncan versus Bonta magazine ban challenge out of California. The fact that these cases are being redistributed for conference this Friday, January 9th, means the justices are in deep discussions about whether or not to take the leap and resolve this issue once and for all. To understand how we got to this point, we have to look at the absolute confusion happening in the lower courts. Back in 2021, this lawsuit was filed in a federal district court in Chicago. While it was pending, the state of Illinois passed an even more restrictive statewide ban called PICA. Around the same time, the Seventh Circuit Court of Appeals decided a different case called Bevis versus Naperville, where the judges came to a bizarre conclusion. They claimed that AR-15s were too militaristic to be protected arms. They ruled that any firearm useful in military service could be banned by the government. The district court, bound by that Seventh Circuit logic, ruled in favor of Cook County and upheld the ban. Essentially, lower court judges are treating the AR-15 as if it were the civilian version of an M16 machine gun, which is both technically and legally incorrect. Now, the petitioners are asking the Supreme Court to step in and resolve this massive conflict. There is a deep split between the circuit courts across the country. Some courts say AR-15s are arms, but can be restricted for public safety reasons, while others claim they aren't even protected arms at all. The lawyers in the Viramontes case argue that the military utility analysis used by the Seventh Circuit was never part of the original tests established in Heller or Bruin, and therefore must be struck down. On the other side, Cook County is trying to convince the court to kick the can down the road again, arguing that the case has procedural defects and the issue is already legally settled. But the truth is that the entire country is in a state of legal limbo. A question many of you have asked is, why does the Supreme Court take so long and list a case multiple times for conference? This is what we call relisting. According to the court's historical analytics, a case that is relisted just once has a much higher statistical chance of being accepted for review. However, when a case starts being relisted 3, 4, or 5 times, like what we are seeing now, it usually points to one of two things. The first possibility is that one or more justices are busy writing a powerful dissent because the court has decided not to hear the case. The second possibility, the one we are all hoping for, is that the conservative wing of the court is negotiating the votes and the specific language they need to ensure that when they do take the case, they have a solid majority to strike down these bans nationwide. To this point, the Supreme Court has avoided the rifle and magazine question like the plague. But we will know very soon whether Justice Kavanaugh is going to stay true to his word, or if that was just an empty promise. If the court continues to avoid this issue, it allows lower courts to essentially run wild and ignore the Second Amendment entirely. However, there is a silver lining here. These two cases have already survived 2 relists and 2 separate conferences. Other Second Amendment issues that went to those same conferences were denied outright the very next week. The fact that Viramontes and Duncan are still standing shows that there is a serious, sustained interest inside the Supreme Court building. If we get a favorable ruling, it won't just affect Illinois or California. It will set a national standard that prevents any state from banning common arms. The AR-15 is owned by over 20 million law-abiding Americans for lawful purposes like home defense and target shooting. By every legal definition, it is a common arm. The Supreme Court needs to clarify that militaristic appearance is not a valid legal reason to strip a citizen of their rights. All eyes will be on the court this Friday for that January 9th conference. So, that is where we stand in these critical challenges. As soon as the order list comes out next week, I will be right here to break down what it means for your collection and your freedom. If you found this update helpful, please do me a huge favor. Hit that like button, leave a comment with your thoughts on Justice Kavanaugh's promise, and make sure you are subscribed to Law Advisor. We are pushing for that 1,000 subscriber milestone, and your support is what makes this channel possible. You can also check out one of the other videos on the screen to stay informed on the latest legal shifts. As always, thank you for your support. This nation was built by armed scholars, and it will be maintained by armed scholars. I'll see you in the next one.